one of the three countries in the world that are at the forefront of biogas technology are agriculture, biotechnology, automation, warehouses. These are fields for tomorrow. You're going to get huge foreign direct investment. No message should be sent from the country and from the court that, look, we're going to tamper with this kind of contract. ONG's filed a petition. This is the first time I've seen ONGC blaming the government of India. 3 blocks, brothers. The area is 7,645 square kilometers. And your lordships will find that oil and gas are in the interstices of the deep sea. This is not something that happens in the continental shelf, brothers, which is 30 kilometers from the coastline. You find them in deep sea, brothers. The government is the sole owner of petroleum underlying the contract area and shall remain the sole owner of petroleum produced pursuant to provisions of this contract, except as regards of that part of crude oil, condensate, or gas, the title whereof was passed to the contractors or other person in accordance with the provisions of this contract. Ownership of government, to the extent, Mullahs, I extract, I am granted ability to sell, permission to sell, I am entitled to do that. That's all that it means. So, Mullahs, the participation of a foreign company is inherent in the contract itself and in the model contract. And that is the basic assumption on the basis of which a foreign direct investment comes into this country. Mullahs, I just pause for a minute because it's interesting. Mullahs, your lordships, I don't know whether you saw it or not, this morning's headline news about biogas. There's headline news about biogas technology, and government has set up a committee. Why, Mullahs? Mullahs, the 3 countries in the world that are at the forefront of biogas technology are Finland, where our Prime Minister went, the Dutch, and Norway. Netherlands and Norway. And Mullahs, they have huge technologies. I myself been there when Science and Technology Minister.
All 3 Scandinavian countries.
I'm sorry? Scandinavian countries. Well, the Prime Minister was there, Mullahs. That's why this has come, because the problem is we need electricity. We need all sources of electricity. And we have to get foreign direct investment, both in terms of finance as well as technology. And how it works there, Mullahs, I know maybe it's an aside, but I'll just tell your lordships. The problem with India is that we don't segregate our waste. Plastics are included in all the waste. So, Mullahs, Mullahs, in that country, there is regulation to say every household must segregate its waste. 1 plastic bag dealing with this, 1 plastic bag dealing with this. Then it's taken, Mullahs, to the site. And then through technology, biogas is produced. So these are things that are going to happen. This is going to be the age of robotics. Mullahs, in sanitation, for example, you don't need a man, a Dalit, to go inside, Mullahs, and collect the scavengings. You don't need it. The robotics will take care of it. Agriculture, biotechnology, automation, warehouses. These are fields for tomorrow. You're going to get huge foreign direct investment. No message should be sent from the country and from the court that, look, we're going to tamper with this kind of contract and give an interpretation which will take away the rationale for coming in. Which is why in oil, we have only 2 companies coming into this country, Mullahs. We have our own Reliance and we have BP. There is no third player. This must be kept in mind by all of us. Anyway, Mullahs, Article 30, Mullahs. In the event of termination pursuant to 30.2, 30.3, and 30.4, or 30.4, government may kindly read B, Mullahs. A foreign company, which is a constituent of the contractor, shall have to remove and export all its property subject to Article 27, and the provisions hereof, provided that in the event the ownership of any property is in doubt or disputed, such property shall not be exported unless and until the doubt or dispute has been settled in favor of the foreign company. Now, Mullahs, kindly to 79. This is very, very important, Mullahs. This will allay the fears of my Lord Justice Bakshi on the interpretation, Mullahs. I just invite my Lord's attention to page 79, paragraph 33.4. which is 33.4 in the production sharing contract also. It's identical, comma, full stop, identical. What does it say? The arbitral tribunal shall consist of 3 arbitrators. Each party to the dispute shall appoint 1 arbitrator. Now see, and the party or parties shall advise the other parties. The 2 arbitrators appointed by the party shall appoint the 3rd arbitrator. Now let us take 2 scenarios. Government appoints an arbitrator. Right, Maras? Who are the party or parties? Party or parties? If it is the parties appoint an arbitrator, then it is party. Government will appoint one. If it's government appoints an arbitrator, the parties will appoint one. I hope I made myself clear. This clarifies in the next 33.5. Therefore, there's no question of the parties being one party because that's defined itself. 333.5. Any party may, after appointing an arbitrator, request the other party. Why bracket parties? Because the parties may appoint an arbitrator. Then it will only be a party. If a party appoints, that means if the government appoints, there will be parties, which is why IES it put in brackets. In writing to appoint the second arbitrator. So the parties will appoint the second arbitrator. But if the parties appoint an arbitrator, the party will appoint a second arbitrator. So inherent in the definition itself of appointing an arbitrator is the contemplation that the parties will appoint an arbitrator. The operator cannot. This is from the model PSC in the production sharing agreement. It is replicated word for word, comma by comma, full stop by full stop.
And in every PSC,
this is a clause in every PSC. Now, then this is the other important thing. And then, if such other party fails to appoint an arbitrator, such other party, within 30 days of the receipt of the written request to do so, such arbitrator may, at the request of the first party, be appointed by the Chief Justice of India or by such person authorized by him within 30 days of the date of the receipt of such request from amongst persons who are not nationals of the country of any of the parties to the arbitration agreement. So the assumption is, Maras, that under Section 11, it's the Chief Justice shall appoint, which means, Maras, an international commercial arbitration. So every term of the contract, every term of the model contract contemplates a foreign entity, Maras, participating in the process of winning any mineral, Maras, consistent with our law. So it's quite clear, Malas, that if this is correct, Malas, then the next question doesn't arise. If our interpretation is correct, then the next question will arise, subject to what my Lord said, there is a big fraud, because fraud unravels everything.
I was only talking about that matter, Delhi matter.
Oh, that of course, that of course.
No, we were only pointing out that why the argument was that in a curative petition, we interfered.
Yes, of course.
We interfered in that case because
The allegation.
case of committing fraud was made up.
No, I agree.
Because in curative, normally, you will be very
That's
reluctant.
also had a lot of ramifications in the international community. I might just...
Pointing out, and rightly so, that in an exceptional case,
Yeah.
you will interfere in curative.
Yes, yeah.
And that's the right way of
Absolutely.
curative scope.
That's right.
But we interfered in that case because we found that it was a case where
Yeah.
fraud was committed.
Yes, I know. I appreciate it. 3 honorable judges, it is not 5 minutes. 3 of your lords. 3. 3. 3 minutes. 3 minutes. 3. 3.
Just the chancellor, just
3. Yes, your lordships. That's all on minutes on this, on the model. No, Millet, I will not read 33.4 and 33.5 because I've already interpreted in the production sharing contract. This is exactly in the same terms.
And the essentials of the PSC.
The essentials of this model are incorporated there. Now, Amalas, I want to make a different argument. I'm not repeating what Dr. Singhvi said. I wanted... That's all right.
Very compilation, Mr.
No. Just the statute. Yes, 21F. If I may, let's read, my Lord Justice Bakshi, may I have your Lordship's attention on 21F. International commercial arbitration means an arbitration relating to disputes arising out of legal relationships. The next is important, whether contractual or not. Considered as commercial under the laws in force in India. So you may have a contractual relationship or you have a non-contractual relationship considered commercial under the laws of India. So forget parties for the moment. There's no doubt, Mullah, there's a commercial relationship between NICO, BP, and Mullah's with the union. No doubt about it, Mullah. Government of India. So that part is established. That part is established. Nobody can doubt that. Forget about the party definition. I'm not on that. Now come to B2. And where at least one of the parties is a body corporate which is incorporated in any other country, in a country other than India. That's a fact. That's not a matter of interpretation. So two things are established here by the definition itself. There is a commercial relationship according to us under the contract. If you start interpreting party and parties in that context, it doesn't matter because there is a commercial relationship covered by the definition. And the second necessary ingredient is I must be a body corporate incorporated in a foreign company. That's a question of fact that nobody can dispute. So how can you say it's not an international?
It's not in dispute at all.
So how do you say it's not an international commercial arbitration? Forget definitions. On its own terms. Once I'm covered that there's a commercial relationship, we say it's contractual and it's clear. But even if it were not contractual, it's a commercial relationship where I get 10%, he gets Muller's 30%, and Reliance gets 60%, or whatever is extracted. And the terms and conditions that are binding on me obligate me to deal with it in a certain manner as set out in the production sharing agreement, which is part of the Model Code of Conduct. So there can be no doubt from any stretch of imagination that this is a international commercial arbitration.
Also clear from the definition of party.
Party means a party to the agreement. That Dr. Singhvi has argued. Let's not repeat what my colleague has argued. So that takes care of this part. And now let's just see, how the impugned order deals with it. Page 39 of the first volume of Reliance. But as we are given, because I have a different brief, but we have correlated it with the Reliance brief because your lordships have been marking it there.
Paragraph 7.
Para 71, at page 39. Let us begin by analyzing the first of the material issues, whether the arbitration proceedings inter se the Union of India and RIL was an international commercial arbitration or not. For this, it would be prudent on our part to commence by tracing back our steps to the observations made by the learned Arbitration Tribunal in the award, which are reproduced below. There is no dispute that the claimant is required under the contract to lead the contractor party under the PSC. Its interest and those of BP and NICO were aligned vis-a-vis the respondent, and they had consistently so acted. However, not being a party to the arbitration, should the costs incurred by each of them be included as those incurred by the claimant and recoverable from the respondent. In the tribunal's view, this should not be. The scheme of the PSC is such that the claimant as operator is the only party in the PSC entitled to deal with the respondent. Neither BP nor NICO had sought to join the arbitration as a party. The respondent had throughout these proceedings maintained that BP and NICO had no right to be heard substantively although the tribunal had on occasions permitted them to make certain statements. Whatever the costs incurred by BP and NICO, if not recoverable as a party, could not be permitted to be recovered through the conduct of the claimant. That was not what was contemplated in the PSC, and the tribunal should not permit it. Interestingly, it is based thereon that the learned tribunal further in its award held, we fully accept and recognize that the named claimant in this arbitration is IRL and that NICO is not formally a party to this arbitration. How does this lead to any conclusion, Mother, that it's not an international commercial arbitration? As I have explained to your Lordship, I am forced to appoint an operator. I have to choose. I can appoint a foreign entity. I can appoint a domestic entity. If the logic is right, the foreign entity becomes the operator, then I'm international commercial. If a domestic entity becomes, I'm not an international commercial. How has the arbitration got to do anything with the definition? And I don't know the consequences. Kindly see a foreign party. I don't know the consequences of this. If I appoint Reliance, I'll be told by a court later that, look, cost will not be awarded to you because he's carrying on the arbitration, and therefore you are not an international, it's not an international commercial. How could any foreign entity ever know that?
There is no remedy available.
There is no remedy available for me, unless it is provided that if you appoint a domestic entity, then only that will be challenged, Mullah, that will be contrary to 2. Even that would be bad. Now, Mullahs, as your Lordship knows, and as was pointed out to your Lordships, Mullahs, first of all, Mullah, just a background. We are the block, there are 3 blocks, Mullahs. I can tell your Lordships, as far as the Reliance block is concerned, the area is 7,645 square kilometers. That's the extent of the block. And your Lordships will find that oil and gas are in the interstices of the deep sea. This is not something that happens in the continental shelf, Mullahs, which is 30 kilometers from the coastline. You find them in deep sea, Mullahs. Now, the block that was with ONGC was closer to the coast. Right, Mullahs? Block given to us by them was a little far away from the coast, but they were contiguous. Part of it was in the deep sea. Part of the first block also was in the deep sea, but mine was all in the deep sea. And wells are dug to find out where the oil is. You never know, Mullahs, what the output is, how much volume will there be of gas, of oil. Nobody knows, Mullahs. It's only when you dig a well, you dig another well, you dig a third well, you get to see the expanse. And then, of course, on the other side, ONGC is also digging wells. They'll get to see the expanse, right? All this information goes to the Director General of Hydrocarbons. This is very important, Mullahs. I have no relationship with ONGC because they're an independent contractor. They will not share their data with me. I will not share this data with them. I will never know whether there is a connectivity or continuity, whether there's a reservoir or not. It's when all the data is collected, you figure out with seismic data and with other data. And because when you develop a site, Mullahs, let me just, so that your Lordship knows the technicality of it. When I develop a site, Mullahs, or dig into a well, I have to give a development plan. Why I want to dig into this well. That goes to the Director General of Hydrocarbons. He will clear it. And as I start digging and I start getting data, I will simultaneously, Mullahs, give that data, forward that data to the Director General of Hydrocarbons. So he knows exactly the progress of the development, right? And each well, Mullahs, and the data each well has to be forwarded to the Director General of Hydrocarbons, just as the data ONGC is forwarded to the Director General of Hydrocarbons. As it happened, Mullahs, ONGC didn't do anything. This is very important for your Lordships to know. ONGC did not do anything. They were only surveying. And my Lordships should also know, they have actually surveyed this entire area much before the contract of 2000, of April 2000. Actually, they were surveying this area even in the 80s and the 90s. So they had a broad idea. And when I showed to your lordships, the pictorial interpretation of where the blocks are, and we're going to upload it on your lordship's computer, your lordship will realize what the nature of the block is, where it was dug, where we found A1 and B1, where we actually found initially that there is oil. Then we start digging others, and all this data is given. And the reason why I'm telling your lordships this is very important. The reason is that when ONGs filed a petition, this is the first time I've seen ONGC blaming the government of India. You will find in the petition, ONGC saying, you people had the data. All that data supplied by me, all the data supplied by Reliance was with you. You would have known from the data that there is a reservoir. You are at fault. This is part of the petition of ONGC. And the government of India replies, the Director General of Hydrocarbon replies, what are you saying? ONGC, you did nothing. You never developed any well. You are the ones who have put us into this trouble. That's all on affidavit. And the data supplied right from October 2002, because your lordships had the impression that we suppressed something. I will demonstrate. The data supplied from October 2002, January 2003, 2004, 2005, 2006 shows that there is a reservoir. Data of ONGC in 2007 itself shows that there is a reservoir. But they did nothing about it. And they blamed us then, that we suppressed a report of 2003. When all of the reports which show much more than 2003 were both with the government and with the ONGC. His own witness accepts that fact. The international commercial arbitrations are not conducted in this fashion. It took 18 months. They looked at every piece of data, every slide, every survey, and then came to the conclusion. They said, I should have forwarded this. It is a breach, but it's not material because they had all this data. What the division bench picks without analyzing anything. In 4 hours, how many hours did it take? In 4 hours, this argument was over. It took 5 years before the single judge. 18 months before the international commercial arbitration. And you suddenly, in 4 hours, you say, no. In 2003, you didn't. So this is suppression. This is fraud. You have deprived the government of India. This is the background. Now I'll take you through the documents.
तो दोस्तों, देश के सबसे बड़े और हाई प्रोफाइल विवाद की परतें पूरी तरह खुल चुकी हैं। ये पूरा मामला हमें सिखाता है कि बिजनेस चाहे कितना भी बड़ा हो, देश के नियम और जनता का हित सबसे ऊपर होते हैं। जहां एक तरफ देश के दिग्गज वकील अपने कानूनी दाव पेच रख रहे हैं, वहीं दूसरी तरफ माननीय सुप्रीम कोर्ट का रुख भी साफ है कि नियम और जनहित से कोई समझौता नहीं किया जा सकता। माननीय अदालत ने दोनों पक्षों को मिल बैठकर रास्ता निकालने का सुझाव भी दिया है, ताकि देश के विकास की रफ्तार ना थमे। कानून और व्यवस्था के इस संतुलन पर आपकी राय क्या है, नीचे कमेंट्स बॉक्स में जरूर साझा करिए। जय हिंद दोस्तों।